Okay, we will go ahead and get started. Just a few housekeeping things. We are recording this presentation. The recording will be posted on the website. I will also add this recording link to the chat. And please do not share any personal information. Following the presentation, you will be asked to complete a short evaluation of the webinar. This will help us with future webinars. If you are seeking social work CEUs, you will need to complete an additional survey that will be shared at the end of this presentation. For questions, you can contact Claire Cook at clairer3@uic.edu. Without further ado, we have Consuelo.
All right. I don't see any slides though. Oh, there it is. Okay. All right. As you were all told, I will like if you have a question, please um, put it into the chat. And I'd like to add, if you have a question during my presentation, it's fine. Just put it in there. Please don't wait till the end because I will forgot what I was saying. And you forgot what you were saying. So anyway, yeah, just put in your questions as we go along. So the first part of this presentation has to do about guardianship. I'm not going to go into a deep dive about this because we could be here all day talking about guardianship. So this is just going to be a little bit of information, uh, general information that you should keep in mind when you start this whole process about guardianship. So, first thing, um, there's a petition that you need to file, and usually it's more than one page. Uh, it's several pages, and it can be difficult to fill out because the courts or legal um, folks have a different way of talking. So, you might want to go to your local circuit court. Um, and every county has their own petition. So you can get a petition from the Will County or the Cook County court, and it will be a different looking document than if you go to a LaSalle County or in any other county. So just so you know, every county has its own little thing going on. And when I say you need to file it, I mean you need to file it via electronic filing, right? All civil cases are being filed now electronically. So that's another twist to this guardianship petition thing. You need to have it done electronically. And sometimes, depending on what county you're in, the circuit clerk staff could be very helpful. It just depends, right? So I can't tell you which are more helpful than others, but it's this whole electronic filing that kind of you have to navigate that in order to file your petition. So the other part of this that sometimes people get hung up on is that all interested parties must be informed. So you're filing for guardianship of your son or daughter, somebody that you love, and you haven't seen the other parent for 20 years or 18 years, whatever, you still have to notify that biological parent that you're filing the petition for guardianship. I know this could be hard for some folks because you don't know where that person is. And the courts have ways of helping you make that announcement. You have to, though, inform all interested parties. Anybody who has lived with the person that you're filing the guardianship petition on, anybody over the age of 18 who lives in the household should be informed. Everybody needs to be told that you're filing this petition. It is not a secret. This is not a secret process. This is something that needs to be shared with all the interested parties, even if the party hasn't been around for a while. Okay. So, thirdly, I'd like to say you have to take a physician has to, as part of the petition, a report has to be done by a doctor. It has to be an MD, could be a psychiatrist, could be a neurologist, somebody that knows the person with the disability. So that doctor has to write a report, and that's the basis of the guardianship petition. So that's what the court holds. It takes a strong, let's put it that way, uh, That's where all the important information should be. So it's not enough for the doctor to write, Joey has Down syndrome. That's not enough. That's not going to get you guardianship. The doctor has to write something about how the person with the disability is functioning, how this disability impacts their ability to make decisions in life. So it can't just be a diagnosis. The doctor has to give us more information than that. Although I have seen, uh, in before I retired, I had seen doctors just write autism. Well, that doesn't tell us much, right? It doesn't tell us how that person is functioning. It doesn't give that information to the judge because the judge has to read this report and decide, oh yeah, this person clearly needs a guardian, right? He can't, there's no way that he can make life decisions on his own. So that's why it's so important to have the physician write something meaningful, something that will give some information to the judge so that he can base his decision on whether or not a guardian is needed to be appointed for this person. And the other mistake I've seen, and I want you all to be aware, I have seen physicians write in the report, oh, this person needs 24 hour, 7 day a week, 24-hour care. Well, think about that because that means that's not your home. Unless you're paying for nursing care 24 hours a day, that's not your home because you sleep, your child with a disability sleeps. So be careful. Usually, the preferred answer when a doctor, because what's one of the things in the report, the doctor is asked to recommend a living arrangement. And what I always like to see is the best living arrangement for that the doctor writes, the best living arrangement for this individual is to live in his loving and supported home, right? With mom and dad. That's what you want the doctor to write. You don't want him to write needs 24-hour care, 7 days a week, because that's not your home. That's an institution that's bringing in nursing care around the clock, and there are some situations like that. And if that's the truth, then that's what the physician write. But if it's not your child, don't have the doctor write that because then you're talking about the judge will have to ask you, well, what placement are you looking for, right? What placement are you looking for? Because that's not your home. All right, so be careful of those. Those are the little uh, things that can get in the way. And once a doctor signs that report, you have 90 days, right? It has to be a fresh report. You have 90 days within which to submit it to the court. So you see all these little tag things that go into when you get into guardianship. Okay. So next slide.
We do have one question. It says, so that is the CCP 211 form.
Well, it depends on for some, I think, did I give you that physician's report? For some, Cook County, that's their form. But like I said, every county has their own form. So you have to look and see what is the form number for every county. Okay. So you'd have to go down to the court and pick up the petitions, right? They have a whole packet for guardianship petition, they call it, a packet for that. So otherwise, I think you're quoting the form for Cook County. But yeah. Okay, so some considerations when you think about going to get guardianship. Again, this is something that you may want to discuss with the doctor who's writing the report because he's the one that's going to write the report and let you know. Well, I think the person needs full guardianship, which means that you're making decisions both for personal decisions and financial decisions, or you just need to make limited guardianship. You need that for your individual, and it'll just be personal decisions one or the other. But I have seen doctors misread this part too, because doctors are not lawyers, unfortunately. And so they may not understand the difference is between a full guardianship and a limited guardianship. So make sure that you understand what this means. And if you're getting confused, hey, welcome to guardianship world. So you may, want to talk to another attorney about this. You may want to talk to your doctor. Make sure that you're understanding what it is you're seeking when you go to court. Okay. And just so you know, a person with a disability has a right to an attorney. So this is a whole process. So all this package that you're filing the petition, you're filing the doctor's report, you're going to file a summons. The summons has to be delivered to the person with the disability. It has to be handed to him. This is a formal legal proceeding. So your person with a disability has to be informed that this is taking place, and the summons will give him the date and time when he has to appear in court. And you will be the persons of who are of interest will also be informed of the date and time of when the petition will be heard, right? This is all, it's going to be a hearing. You all have to go down to court and you're going to have, the judge will read the petition, the judge will read the report from physician, the doctor, and then he'll make his decision, right? And then he'll decide, oh, yep, here's the guardianship, here's the papers. It's all a formal process, right? And so I want you to understand that the judge will be signing, if you get guardianship, what he will give to you is a piece of paper. And that piece of paper, it's very important, obviously, but it's just a piece of paper. I've had parents tell me, oh, I really need guardianship. That's really going to help me with my son or daughter. And I'm like, okay, I just want you to realize that you're just getting that piece of paper. If you have a child who you have trouble getting to the dentist or getting to the doctor, they could care less that you got guardianship and that you have this piece of paper, right? You still have to get your son or daughter to whatever it is they have to do, right? It's not powerful. This is just a piece of paper, and it gives you the power to make decisions on their behalf, but it certainly doesn't impress them in any way. Let me tell you that right now. They're not impressed that you went to court and you got the judge to sign off on this order, and all of a sudden they're going to listen to you and they're going to obey every command that you have. Doesn't happen. I can guarantee you it doesn't happen. They could care less that you got this piece of paper. So, you still have to work on your strategies on how physically you're going to help your child with a disability make it to the doctor's appointments, make it to the dentist appointments, make it to all the things that he has to do. Because that piece of paper isn't going to help you. Yes, you have that right to make decisions, but on the other hand, physically, it really doesn't help you a whole lot. So I just want, parents tell me, oh yeah, I got, it's really important for me to get that. I got to do it. But I want you to understand that in the end, you still have to deal with what you have on your hands. Okay. So next slide. So the major things, there's some rights that you lose. There's a lot of rights that you lose, but some of the major ones are you cannot, if you are under guardianship, you cannot drive a car. You don't have a license. You cannot have a license to drive. That's one of so if you have a child who has that ability to drive, why don't take that away from them? Because driving is a big thing, right? If you can get to drive to work, that's a big, it's a big privilege, but it's also something that really helps them in their lives, right? To be able to drive. And once you've lost that, it's really hard to get it back. You lose the right to own a gun. Well, whatever. And you certainly cannot enter into a contract because you've just been, the court has just found you unable to make your own decisions. You're incompetent, basically, is what the court is saying. And I want you to also understand that once you are, once you've gone to court and you have the guardianship, you got the order and everything, you're pretty much tied to the court. You're going to have to write reports annually. It depends on what county you're in. Some counties will give you 2 years, maybe a couple will give you three, but mostly you do have to continue. You will be under the jurisdiction of the court. They gave you the power to make these decisions. And so now, in order to continue having that power, you have to report back to the court. You have to tell them what's happening with the person with the disability. Where do they live? What are they doing? How are their, what's going on in their lives? And I don't know about you, but I write enough reports. I have to give, redetermination to DHS. It was something that it's another report you have to do. So I just want you to be aware of that. This is not a private process. Doesn't stay. Anyone can look up the court records and see that your child is under guardianship. Um, but also the main thing is that you have to continue under the jurisdiction of the court and have you know, do reports to them as annually or as often as they have requested you to do that.
We have one question. It says, with limited guardianship, they cannot obtain a driver's license. What about just financial and medical guardianship?
Okay, so all right, see that there you go. That's why I didn't want to get too deep into this. That's why if you're having trouble with this, you may want to speak to an attorney. So limited guardianship means you have guardianship of one part of a person's life. You have guardianship of just their financial, or you have guardianship of their personal uh, decisions, right? So that's the split. So either one of those, right, will get you incompetent unless the doctor writes something in there about driving. So you're going to have to write that language in there about what you're seeking in your petition. You want guardianship, personal, but you want your person to be able to drive. You're going to have to put that into the petition itself, and then you're going to have to support that with evidence that your person is capable of driving. So there are places out there where you can get driving evaluations to support your petition. So if you want to reserve a right, right, the right, like the right to drive, and you're seeking guardianship, you're going to have to do a little extra work to get that. Okay, does that make sense? You just have to support whatever you're writing to the judge. You need to support it because he wants to see evidence that, okay, I'm going to give you this limited guardianship, but I'm going to reserve the right to drive. Here's your support. Okay, got it. You got to give the evidence to the judge to support what you're asking in the petition. Okay. But again, if it gets complicated, you may want to talk to an attorney or, you may not want to do this by yourself. Okay. So, any other questions about guardianship? So basically, they're been judged to be incompetent, and that's the key point I want to get to before we get into the supported decision making. Okay, so because that it changes everything. Everything goes different when you go to supported decision making. All right, so next slide. Unless there's another question about guardianship.
No other questions.
Okay, that because I want to move on to the fun stuff here. All right, so supported decision making. Phew, this is where things change. So, and it's been the law in Illinois since 2022, so fair, relatively new. Fair. And so, next slide. So, what does this law do? First of all, it it authorizes the use of supported decision-making agreements, and the law specifically says that a person with an intellectual disability and or a developmental disability is presumed to be competent to enter into these agreements. Okay, so kind of different from guardianship, right? Because there we're looking at the person with the disability and we're saying he's incompetent. Here we're looking at the person, and the law specifically says that this person who has an intellectual disability or a developmental disability has the capacity to enter into this agreement, is signing this contract, is signing this agreement. He's part of this contract, and that he is legally authorized to do this. So a big change, right? Big advance for people and with developmental disabilities um, to have their rights recognized and have their decisions respected. So that's what this does. So it authorizes the use, this whole law, the supported decision making, authorizes the use of these agreements, and it allows a supporter to assist a principal with an intellectual or developmental disability in making decisions. So there's a total shift. Rather than somebody appointed as guardian making decisions, this is a shared kind of responsibility, right? We're not brushing that person aside. Of course, guardians don't. I'm not saying they do, but I'm just saying this is a whole different leveling of the field here, and we're respecting uh, under the law these rights that the person with the disability has in making their own decisions for their life. Okay, so next slide. So it's an alternative to going to court, right? It's free. That's the other thing. Court costs. I didn't mention that, but court costs, right? Anytime you go to court, it's going to cost you. If you take an attorney with you, it's going to cost you more, but it's going to cost. This is not only free, it's 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 private, right? There's all kinds of things. And it is the law, the supported decision-making law, which by the way, I have forwarded the law, the actual law to Claire, so it should be on the website. And you may need it, and we'll talk about why you may need it. But anyway, so under the law, the supporter is authorized to access, collect, and obtain information that will help the principal in making decisions. And the principal is supported in making decisions. But they're not deprived of any decision-making power. And that's the key. There it is, right there. That's the key. And it's probably the way, if you have started when your child was little about making choices, this is the way your family has run, right? You've presented choices, you've talked about it. If you eat that, we're not going to eat that big dessert before dinner. We're going to eat it after dinner because then you won't eat dinner. These are choices that we've been given, and we've shown our children about choices throughout their lives. So it kind of continues that whole thing. And so, I mean, and it's a good alternative and it's legal and it's all of this. So why would you want to go to court, right? You already got the power to help your person make decisions. You're collecting information, you're sharing information, you're talking about different things with your person with a disability, and boom, the decisions are being made. So it's a nice alternative to going to court. So were there questions? People are getting,
Someone
oh,
was just asking if there was copies of the slides.
oh, okay. And okay, I won't
I
have.
gave them the website.
Okay, great. All right. So next slide. So I wanted to give you some updates about supported decision making because as an retired attorney, I'm still nosy, that I'm still curious. But anyway, so right now there's about 13 states that have supported decision making on, or 15, sorry, 15 states that have supported decision making on their books, Illinois being one of them. Texas was one of the first. And really, there have been no legal challenges to this law. People accept this. And it's probably on behalf, good job that the advocates and people with disabilities have done in supporting this law and in maintaining the law and seeing that it works. And so no great legal challenges have been made. And really, the federal law, well, for a while anyway, has said, if you don't provide an alternative to guardianship, you're basically denying people with a disability the least restrictive options out there. And that's what the federal law, 504, the ADA, we're looking for least restrictive options for people with disabilities. And this is it, supported decision making. So many states are getting on board now. About this law. And so I just wanted you to know, I mean, it's good law. It hasn't been challenged. And as a matter of fact, the feds, when you look at how um, least restrictive options have been becoming more and more and more available to people with disabilities, you realize, hey, this totally makes sense. We need to have this option as an alternative to that restrictive option, which is going to court. And I want you to know that it has been recognized by provider entities and health insurance companies. And that's why if you ever get questioned, and you shouldn't, but somebody comes to you and says, I don't believe this is legal. What you're saying, the supported decision making, it's not legal. So I have given you the law in Illinois. It's part of the information that's going to be on the website for the support, your website. So it'll be there. So if anybody ever questions, wait a minute, is this really legal? Yes, it is. Here's the law. And so the recommendation is you give them a copy of the law and you give them a copy of a release of information which your individual with a developmental disability and an intellectual disability is authorized to sign, because that's what we're doing here. They're authorized to sign release of information, and that should take care of any questions that this provider or the bank or dentist, whatever, has. And I think I've already mentioned this. I think the thing I like most about the supported decision-making option is that it continues uh, pretty much how families really do function, right? We ask and we support each other. We don't make decisions in a vacuum, right? I'm going to do this. I'm a liberal, No, we share that information and we share what we're doing and we consider options and we discuss them and we look at each other and we talk to each other and, share what we're thinking and what is the best thing that we can do here and how does this work. So I think that's what I really like, that it's part of how we function as families anyway, and that we're just supporting this and we've just legitimized it by making it a law. Hey, it works. Okay, so will one next slide, please. So I wanted you to think about for future consideration here, because this may come down the line. So some states have already passed laws that if you haven't tried supported decision making first, it's a prerequisite before filing for guardianship. That some of the states have done that. It's not a prerequisite here in Illinois. It's consideration, but it's not a prerequisite legally, right? You can go straight to court and file for guardianship. You don't have to have a supported decision-making agreement and have it fall apart or whatever. So, but I want you to know that Illinois is considering making it a prerequisite, which would mean that you could not go directly to court for guardianship. And I'm only talking about people with, who are turning adults, they're becoming adults. They're the young people with intellectual and developmental disabilities. I'm not talking about, Aunt Rose who can't remember, what's going on, right? We're not talking about those kind of folks. We're only talking about those kind of folks. You're going to be able to go directly to guardianship and, help them because, they need help. And in a more restrictive way because can no longer, they're not under the law, they aren't competent to sign these agreements. The only people who are the people with intellectual and developmental disabilities. So I just want you to think about this. This isn't the future. It hasn't happened now. It may happen in the future that Illinois may go to a prerequisite before filing for people who have intellectual and developmental disabilities. And I also want you to understand that what else is happening under supported decision making, because, and this is happening with the public guardian and other people, private guardian, um, people who are under guardianship aware that there's now this law about supported decision making. Before they didn't have this option, right? So people would get guardianship because it was the only way to help make decisions, right? You need help making decisions. The only way we can help you make decisions is going through the guardianship petition process. But now we have this alternative. And so now before it was very, very difficult to get out from under guardianship, right? Because you had to prove that you were no longer competent. Well, it's hard to do that if you have an intellectual and developmental disability. But now we have this law that says, hey, they are competent. And so many more people are going through the process and getting their rights restored because there's an available option out there that will help them continue, give them ongoing support to help them make decisions. And it's less restrictive. And so the judges are granting some of these petitions to restoration of rights as long as there's a supported decision-making process in there somewhere, right? To help that person continue making decisions. So I just want you to know that this happening here in the state of Illinois, that more people are getting their rights restored. Um, and it was very difficult before we had this option, this alternative. So I just wanted you to know about that. Okay. So let's talk more about supported decision. Next slide.
We actually have a couple of questions.
Okay.
If supported decision making is not appropriate for your child, when is the optimal time to petition for full guardianship?
Okay, again, that, you know, it's hard for me to answer that. It depends on your family, it depends on your doctors, right? Sometimes doctors who are pediatric doctors will continue to see your child until your child is well into their 20s, and they never ask, right? They never ask for your authority to make decisions because they've treated your child since he was a baby, right? So it just depends on your personal and decision of when is it appropriate to seek guardianship. When you need it is what I want to say. I mean, when is it appropriate? And if you don't need it, don't go for it, right? If you've got a supported decision making agreement in place and it's working for your family, why are you going to court? Right? So, that's a difficult question for me to answer. It's, like all attorneys, it depends. Uh, so, anyway, another question?
Yes, there's two. If I apply for guardianship for my intellectually disabled son, will he be disqualified from Social Security?
No, absolutely
No.
not. Has nothing to do. Okay, that's one thing I want to make clear. Social Security is federal. Those are federal laws. Social Security is a federal program. Guardianship is a state animal, state run, right? So the two have nothing to do with each other. Sometimes, Social Security will ask if you have guardianship, but the two have nothing to do with each other. One is federal law, one is state law. Okay.
And the last question, is there a form for supported decision-making contracts?
Oh, good question. And we're getting to that. We're getting there.
Mhm.
We're getting there. But first, let's go through this. All right. Next slide. Okay. So, supported decision making. What does it cover? Well, it covers all these basic and more if you want. It covers your basic decisions of life, right? Obtaining food, clothing, and shelter, taking care of your physical and mental health, managing financial affairs, applying for public benefits, helping someone to find work, helping with school decisions, and advocating. Any kind of advocating that you need done, it can be done under supported decision making. And so, just so you know, with school decisions, so your child turns 18, there's two options here now. At 18, your child can sign the ISBE, Illinois State Board of Education Delegation of Rights, or your child can sign the supported decision making agreement. So, okay. Now, the difference, let me tell you the difference. The difference is ISBE form, the Delegation of Rights, your child is giving up all decision rights, the right to make decisions at the IEP meeting, to the parents. Again, under supported decision making, you're sharing that decision making, right? You're supporting that person making the decisions. Your child does not lose the right to make decisions. So you need to decide how you want to run these IEP meetings. And very often, very more advocates are saying, you know what, your child should, this is where it should start, right? It should start at school, making life decisions of what's important and how are we doing this and practicing. And it's a good place to practice, right? In school, because I mean, the consequences are big, but not life and death, right? So, so you might want to consider starting your supported decision making, you know, as you did when he was little, right? You might want to start in school. And it can be an IEP goal too, which is nice. Supported decision making is our goal. Here's how we're going to practice making these decisions. We're going to share information, whatever. But I'm just saying, look at the school because it starts at age 18. Where do you want to start having these decisions being made by in a supported decision making format, while you're still in school, or do you want to wait? Whatever. But I'm just saying, it's something to think about because you can, at age 18, that's when you sign these important legal documents, right? Okay, next slide. And just so you know, the law did include agreement in there. So part of the law, if you ever sit down and read the 13 or 14, whatever pages it is, the law is written in, you'll see embedded in the law is this agreement. And the agreement, and it's separated, right? We have separated it, and you'll see it on the division website. It's there. It doesn't need to be notarized. When they were thinking about how this should play out, they wanted to make sure they weren't building barriers into this process. They wanted to make sure that this could be as barrier-free as possible. So as legalistic as the guardianship petition is, this is way not that. This is to be done, at the kitchen table, bring your neighbors over, you need two witnesses, let's sign here. This is our agreement. This is where we're going to start this whole legal process. You just need two witnesses. You don't need to have it notarized. It should be friendly, private. Nobody else needs to know about this except, when you give it to people that need to know about it. It's our business. It's our family. This is how we function. We're friendly. We're open. We're in the family. We do this together, right? So you need two witnesses to this agreement. The principal and the supporter need to sign, and there you'll see the options are there. And it's only 3 pages long. It's very, very easy to fill out. It doesn't get complicated. It has a place where the witnesses can sign. And I want you to understand that there could be more than one agreement, right? You saw all the decisions that are being made, the obtaining the food, the helping me with school. One person doesn't have to do all of the supporting. It could be broken down. A couple of people could do the supporting, right? All of the agreements have to be signed and witnessed and all of that, but it doesn't all have to be one person, okay, or two people. It can be more. You just have to make sure that you formally addressed who will do what. Everybody's got their specific assignment. Everybody's got their specific decisions that they're going to be helping with. And how are we working with that, right? So I think that's nice because it's this shared responsibility. And, we all have different people we go to. Uh, you know, there's some people you wouldn't trust with your money. Hello. You wouldn't trust to talk to them about your money, but there's other people that you would trust to talk. And there's some people you would never talk to them about your health, right? Especially not your mental health, right? But there are other people that you would talk to. So that's I just want you to point it out that, it doesn't all have to be one person. It doesn't have to just be one agreement. It can be several. It can be a shared responsibility. So, next page.
We have one question. It says
Uh,
if the principal can't sign, i.e., they don't write, does that exclude that person from supported decision making?
no, absolutely not. Absolutely not. Because these, what we're accepting here is whatever signature or whatever stamp, whatever they use to identify themselves on paper, that's what we use. So we're not trying, this is what I wanted to emphasize. We're not trying to eliminate anybody from this process. We're trying to make sure that this is a barrier-free document, right? Whatever you need, whatever you use to identify a stamp, whatever, that's what you use here. So, so long as it's your legal signature, right? And that's what you use to legally identify you as a written whatever document, that's what you use. So uh, it could be a stamp, it could be your fingerprint, whatever you use to legally identify yourself in writing, that's what you use. Okay. And if it's even if it's an X, that's what you use, right? Whatever it is, that's your signature. And then you can just say, you can have a separate document saying that's your signature, right? Okay. So the Illinois Guardianship and Advocacy Commission were instrumental, right, in coming up with the law and helping develop the law. They were working with advocates, they were working with people with developmental disabilities, and they came up with this agreement. The form, like I said, is embedded in the law, and it came out to be 3 pages. It was a little bit, you know, they had a different form in the beginning and then but it was all straightened out. Now we have this great form. It's on the website. And so I want you to understand it's legal. It's not, it wasn't just brought out of the sky, right? It's just this really nice form. Like I said, it's 3 pages long. Now, you can use another form. That's part of the law says, you know what, you don't like this one that the Illinois Guardianship and Advocacy Commission came up with? Hey, make up your own form, right? Basically, you need to have this information in it, right? So you can make up your own form, but why would you, right? You got this great form that they made up for you. Use it. Uh, and it's got some great things in there, and we'll talk about that. So, yes, it's part of the law. It's just 3 pages. Pretty easy to understand. So let's continue. Okay. So this is a question that gets asked a lot. Well, who can be a supporter? You know what? It can be anybody, right? A friend, your parents, your sibling, a cousin, an aunt, an uncle, anyone who is interested, right? Who cares? Because this is and is trusted. I want to put that in there. This is not something that you would want to do, uh, not legally speaking, but anyway, half-assed, right? You don't want to be a supporter and be half-assed about this. If you're going to be a supporter for somebody making decisions in their life, you're going to be a supporter, and you're going to be helping that person make life decisions, right? So, and it's not every day, right? It's not every day you're making life decisions, but they are important decisions. So you have to be there. And so that's why, you know, usually the first people to sign up are going to be parents, right? Because we're there for everything, right? So, but it could be somebody else. And we as parents need to share how we're doing this, right? Again, family, be private, be respectful, but you may need to share this information with other people. So, and there are people on the next page, please. And I'm going to go through quickly because I don't want to miss. But anyway, so there are some people who can't be supporters, and usually it's somebody who has some kind of financial interest in the person with the disability, except for parents, right? Some of us are workers, right, for our adult children with disabilities, but it's okay for us. Whereas parents can, but not okay for other people who have some kind of financial interest in the person with a disability. And of course, if you're a crook, if you're a bad person, if you're a thief, you probably couldn't be acting as a supporter. You shouldn't be acting as a supporter. Okay, so next page. Sometimes people ask me, how can we get rid of this supported disagreement? Well, anytime the principal or the supporter this is, you're not locked into this for the rest of your life. If things change, people move on, you can change, destroy the paper and do another agreement, right? Very easy to do another agreement, which I also like this flexibility, which you don't have at court, because when you want to change guardians, guess what? You got to go back to court. So this again is so much easier. Than the guardianship petition route, right? So I just want you to keep in mind the flexibility that you have here, how easy it is to do, and free. It's free, and how private it is. Continue to do this um, in your own home. Okay. So moving on, next slide. So who needs to accept this agreement? Okay, like I said, anybody who you give it to should accept it, right? And if they give you a problem, hey, here's the law, here's my release of information. This is his right. He's got a disability, but it's his right under the law. Everybody should be accepting it. And as far as I know, everybody has been accepted. No problems have developed around this. Okay. So next slide.
We actually have one question. It
Okay.
says, I just pulled up the form. My question is the principal an adult with IDDD? Does it include a person with a neurodevelopmental disability? Their IQ is above 71.
That's a good question. And I think it would, you know, one of the things I go by, if you've been accepted on the PUNS list, then you can sign this. If you haven't and you have a question, I would talk to your doctor, because many people who have a neurological are considered, even though their IQ may be higher, would be considered to have a developmental disability. So I would talk to your doctor, physician. I'm not a doctor, so I can't tell you, but I would talk to them and see if they would be eligible. But if they're on the PUNS list, boom, that's it. They're eligible. Um, they're considered to have a developmental disability. Okay. Sorry, I'm not a doctor. Okay. So the role of the supporter, and it's right here in the document itself. Right? And that was a good question, by the way, because the principle, there is a definition there, and it's in the law too about what exactly is the principle. It's that person with the intellectual or developmental disability. So you have to be considered to have either one of those to become a principal in order to sign this. So the role of the supporter. So basically, you cannot make decisions for the principal. You can't be paid. That's the other key component of all this. There's no payment. Uh, you're doing this out of the kindness of your heart. You want to help this person make them make decisions. And you can be disqualified. There's a whole section in the agreement about if you're found, um, you know, it kind of puts a layer of protection in there for the person with the disability. If someone who receives this agreement sees that the supporter is stepping out of bounds, is charging or getting gifts from the person with the disability or whatever, something's fishy, they have to report to the office of what is it? Some office here of abuse and neglect, right? And there's a whole number here that you can call. They can call and report the person who is abusing the person with the disability. So there's a layer of protection in this whole agreement so that everybody is told, look, if you see something funky going on, you see that person exchanging money for their services or whatever, then no, they have to be reported, because that's not what this is about. All right. So, so I kind of like this, that they put in this kind of a little layer of protection, right? Because mom and dad aren't always going to be here, right? I know we're not going to cheat our kids, but who knows what's coming after, right? So also next slide. So this is also in the agreement itself, right? That your duties as a supporter. You know, you have to act in good faith and be loyal and not act in self-interest, right? You're not pushing that person towards, uh, giving you money, right? I mean, this is all about the person with a disability, and you're avoiding conflicts of interest. And so you'll see this when you sign as a supporter, you're making a big commitment, and you're giving, um, when you sign on, you're giving all this information. They want your name, your address, your phone number, your email, because when you give this form to other people, to third parties, they will be watching, and they have a right to report you if you're messing up, if you're not doing what you're supposed to be doing. So, you need to take these duties very seriously as a supporter, right? And that you're helping the principal, you're not making the decisions for them, and that they're making their own decisions. But with your help, I think the point is that this is something that needs to be practiced. This is something that starts when the person with the disability is very young. And, and you can be a role model, right? How do you make decisions? Make them out loud. How do you make decisions, right? And put that voice so that they understanding how you're making decisions. I'm not going to spend my last $10 at the zoo because I need to buy groceries, whatever. I mean, you have to take these very fundamental decisions and make them real for the people with disabilities, right? And you start with how you think, how you are making decisions, and voice that out loud so that they're hearing this, right? And you can help communicate decisions, but very often people are going to want to hear it well, they have to hear it from the person with the disability. So you see, the supported decision-making agreements, they're not for everybody, right? They're not for everybody. But there are folks out there that can very well function with the help of supported decision-making agreements, right? It's not for everybody. I'm not saying it's for everybody, but if it's an option that's available, and it's helpful, hey, let's use it. So here it is. Okay, the next slide tells you it's for the adult. You call the Adult Protective Services Hotline if you become aware of some kind of abuse that's happening between the supporter and the person with the disability. So I think that that's nice. We as parents, it's nice to know that this is going to go forward and that someone's going to have their third parties are going to have their eyes on this agreement. Okay, I'm almost done. So the next slide, I always, because I do this in Spanish, I talk to families that have different immigrant status, because I made the call directly to the Illinois Guardianship Commission, and I asked them, you know what? I have families asking me, my son, I wasn't born here. Can I sign? Can I be the supporter? My son wasn't born here, but he's living here now. Can he be the principal? And the answer is yes. So anyone, so long as you reside in the state of Illinois, you can sign this. And by reside, I mean, you're leasing a home here, or you're renting a home, or you're buying a home, whatever. You live in the state of Illinois, you can sign this. Doesn't matter what your immigration status is. And this is very helpful because just today we received from Will County documentation that people were being arrested for immigrant status from the courts. So this is a nice option for people who really shouldn't be going to court right now, to be able to help their child with a disability make decisions. So. So I think that that's important for everybody to know. All right. Anybody can sign these as long as you're residing in the state of Illinois. Okay, last slide. So this is the information. If you want more information, I would totally go to the Illinois Guardianship and Advocacy Commission website. They have tons and tons and tons of information about guardianship, and Teresa Parks is the key person there. She's very knowledgeable. If you ever have a question or somebody's hassling you about your supported decision making or whatever, she is a great resource to touch base with. I put it into the PowerPoint so that you could have that because they are a great resource. They helped write the law. They're advocates for people with disability, and they're like I said, they're looking to keep um, reforming the law and making it better and stronger. So, whew, I think we got it all in, and there were some questions that needed to be asked.
I don't think there were other questions. I think it was just a lot of thank yous and that it was really helpful.
Oh,
Do
good.
we have any other questions?
This is the time to ask. I wanted to get through fast so people could have time. Mm.
I'm going to enter in, if you are looking for social work education credits, the form to fill out for that. Oh, here's a question. How should I advise a family who moved to Canada to get guardianship of their children but want to get care in Illinois?
Oh, that's a toughie. Uh, because like I said, it's a state rule, right? So generally speaking, when you go to guardianship, you need to be living in the county in which you're seeking guardianship, or the person you're seeking guardianship lives in that county. So you can do it from out of state, but it's just going to be much more difficult. Okay, so you need to know where that person with the disability is living, where they reside in Illinois, and that's the county you have to go to file. Now, you may have to file something in Canada, but so long as you're a U.S. citizen, I think it would be all right. But the county is what's important. The county where the person with the disability is living, that's what you're going to have to file, and then tell them that you're residing in Canada.
Any other questions?
Oops.
Oh, okay. Well, I think it is 7 o'clock, so we're going to go ahead and conclude, and we will send the slides and information sometime. Oh, tomorrow. Is there any reason to do this for a 15-year-old?
No,
No.
no, you're a mama, you're a mama and have decision-making authority over your child until the day after their 18th birthday. So many teenagers don't understand that, but but you still can make decisions for your child, and he's still considered a child until the day after his 18th birthday. And usually a lot of people go for the whole month that the child, or his birthday month, that he's 18 until the net following month when, okay, you're born in May, your 18th birthday is in May. So generally speaking, most parents have some authority until the following month in June when the child is 18 all month long. Does that make sense? So that's why most people wait until the following month after the 18th birthday to file at Social Security. So, but, you know, but certainly a child of less than 18, you're mama and you're papa, and you have the authority to make decisions for them. Yeah. It's that 18th birthday that's the magic number, the
So,
adult number.
so what is the timing for doing it before the 18th birthday?
You don't do it before the 18th birthday. Like I just
Right.
said, your mom and dad, you have the power over that child until after their 18th birthday. And usually that month, it's the next month that you worry about. that you, but on the other hand, right, when your child turns 18 that month and then you go to Social Security and you tell Social Security, they're on their own, right? They have to pay rent, they have to pay food, they have to, most parents, we continue supporting our child, but there are some parents that say, 18, and they have every legal right to do that. You're out of here at 18. I'm not going to support you anymore. And legally, that's okay. But a 15-year-old, you have to support. It's the law.
We have a question in Spanish. Oh, Isaiah, can I pick up the form in person? Is there anyone who can guide me on how to fill it out?
Yeah. That form is available. Guardianship and Advocacy Commission did translate the form, the agreement. So you legally you have to complete it in English, but at least you follow it in Spanish since you know what you're signing and what the understanding is. And actually, Maria and I are going to be at the transition conference this fall, and we're going to be just doing that very thing. We're going to be filling out these forms in person. We're going to do some role playing, we're going to do some other things, but yeah, we're going to be doing that to help parents understand because a lot of times people are not understanding. What do you mean? What does this mean? I think the form is very simple. But again, I'm an attorney, so but they tried to make it as simple as possible, but it still can be challenging to understand. But yes, there are people that can help you fill out the form. And like I said, if you want to reach out to Teresa, there are people at the Illinois Commission that speak Spanish that can help too. And again, this cannot be signed until the child is over 18. Okay? Under 18, you're still a child.
I think that's everyone. Well, thank you so much, Consuelo, again.
No problem. And thank you for all your help here tonight.